stories, the highlights from today. Njonjo and Khelef Khalifa, the petitioners seeking the annulment of the presidential election, are this evening grappling with the magnitude of their request, which was granted by the Supreme Court after the IEBC slapped them with an 80 million shillings bill.
Well, the Supreme Court had this morning ruled in their favour by granting their request to gain access to all Forms 34A, 34B and 34C. The petitioners were also granted permission to have a copy of the voter register used during the October 26th election. Njonjo reports.
The second respondent is also to avail a certified copy of the voter register to the petitioners at the cost of the latter. That means the petitioners. And this is in accord with prayer number 17.
A wish granted, but one that even the petitioners knew would face a hurdle, the exact nature not clear to them then.
And if we have difficulty, we'll be at liberty to approach the court. Thank you.
Very well.
Thank you.
Thank you.
But now it's clear. The firm of Lucy Kambuni, one of the lawyers for the respondents on the Njonjo and Khalifa petition, has written to the firm of Julie Soweto indicating their willingness to comply with the court order of availing a hard copy of the register, but at a printing cost of 80 million shillings. The 4-paragraph letter from Kambuni says Soweto should indicate availability of the funds before the printing commences.
Now, my lord, even if you assume we are 20 million voters in Kenya and that each voter has one page in a register, it would take, and if you were to photocopy at 20 shillings per page, you would only need 40 million. Asking the second and third petitioners to pay 80 million shillings in advance is difficult to understand the basis.
As regards the cost, that is really a matter. You want 450,000 pages, there is a cost to pay for it. You can't ask for something and then not have the will to pay for it.
The scrutiny of the documents began this morning. The parties told the court different versions of the exercise. While the petitioner complained of hurdles from the IEBC, the respondents were happy with the process but accused the petitioner of attempting to change the scope of the order.
So if the court may direct that the third respondent, if he's not interested, fine, but the first respondent should provide the access immediately as we expected in the morning.
Parallel to this process, the hearing of the consolidated petition proceeded at the Supreme Court, with the petitioners arguing that there was need for fresh nominations before the October 26th election.
The first and the second respondent could not say, they could not foresee the difficulty or the challenge in holding an election that met all the principles under Article 81E, under Article 1 of the Constitution. It was not for them to decide whether some Kenyans get the right to universal suffrage and other Kenyans get an election that is free from violence, intimidation, improper influence.
Harun Mwau's lawyers told the court that there was need for the election to happen in all the 290 constituencies and that more than 1.6 million voters did not take part in the exercise.
My lords, when elections are null under Article 140, none of the previous candidates, none of the previous processes is saved. All processes are done away with, and actually in your order you said that election was null and void. So it's like it did not exist. We all know the meaning of that word.
The respondents told the court that there was no legal requirement for the commission to undertake fresh nominations. The violence in the 4 counties was also given as a reason for the inability of the commission to undertake the election in those areas.
How much violence did they want to, would a commission have waited to take place before it said we need to postpone these elections? Is it to wait until people have been killed Is it wait until property has been destroyed? And so, my lord, it did the correct thing in taking the decision to postpone the election to save loss of life.
While addressing the matter of withdrawal by Raila Odinga and if it affected the election, the respondents told the court the law does not foresee a situation where a candidate can come and go at will, having been gazetted as candidate for an election. The case continues. Ken Njonjo, NTV.